All right, well, good morning or good afternoon, depending on what time zone you might be in. This is Sharon Toerek, and on the line with me is Jody Sutter, whom I'll introduce in a moment. But I wanted to take a second to welcome you to the TAAN webinar on negotiating client contracts from a position of strength. I can tell you that as an attorney representing agencies, this is probably the most frequently requested issue that we get here at the firm from our agency clients is how to handle contract negotiations, how to handle contract review appropriately. And so we know that it's on a lot of your minds day to day running an agency. And we thought it'd be interesting to talk to you from the perspective of not only an attorney, but also a business development professional. And on that note, I'd love to introduce my co-presenter today, who's Jody Sutter from the Sutter Company.
Hi, everyone. I'm so happy to be doing this. This is my first TAAN webinar. So thank you for having us here today. Yeah, I'm a business development consultant, coach and trainer, and I work with agencies, mostly smaller agencies, but ones that have made a commitment to controlling their new business destiny. And I help them get their positioning and their strategy right. And then I work with them to put in place systems and structures so that they can sustain a successful business development strategy on their own over the long term. And yeah, as Sharon said, I think a lot of times people look at these issues as purely legal, but a lot of times the decisions that you make when you negotiate contracts with clients are going to affect how you are able to, both the success of the relationship with that client, but also how you're going to be able to pursue business development in the future. So we're going to talk a little bit about that.
Yeah, and again, and Jody, I love the opportunity always to present with you. Jody and I have done this a couple times before, and I always enjoy the conversation. I have met some of you who are on the line through my attendance at one of the other TAAN functions this year, and had an awesome experience meeting and talking with many of you. I'm Sharon Toerek, and my firm Toerek Law works with agencies to help them protect and monetize their intellectual capital. And we also host for agencies on innovation in the agency space called the Innovative Agency Podcast. And I've also created a legal toolkit of sorts for marketing agencies. With that, to give you the lay of the land today, what we'd really like to talk with you all about, it's a function of us seeing patterns in both of our work, me from the legal perspective and Jody from the business development strategy perspective. And when you do that for a while, you do start to see patterns. And so what we'll talk today about is, first of all, typical mistakes that we see many clients make during the business development or pitching phase. We want to give you some strategy for avoiding those mistakes so that you make deals that protect your agency and that puts you in a stronger financial position vis-a-vis that client, and also give you some suggestions about tools and information you might need to be stronger, more effective negotiators with clients during the new business process. And Jody has a story to kick off.
So, yeah, before I get to that, I think that sometimes we agency new business people, and I'm also not as familiar as Sharon is with the folks that are on the line, but my guess is that we might have some agency principals. We also may have those who are responsible for business development. That might be the same person, that might be different people. But what I found is that when agency executives are in business development mode, they tend to have a reputation for saying yes when they want to win clients over. And I think that's because we really want to show that our agency is enthusiastic and gung-ho and easy to do business with. So we say yes to all sorts of things like spec work, late hours, unreasonable deadlines. And I think that's why some of us find negotiating contracts with new clients daunting. It often requires us to push back. I mean, that really is the nature of negotiation. Although if we start to push back and we're trying to show the client that we're gung-ho and easy to do business with, doesn't that undermine it? Doesn't that potentially put us at risk of the client not liking us so much? So in response to that, I say, look, we're in a services business and I put equal weight on both terms. From the first moments of a pitch, I think you have a responsibility to your agency to set yourself up for a mutually rewarding relationship with a new client. So here's a quick story of how I overcame some of my fears and uncertainties around negotiation. At the time, this is a bunch of years ago now, I was doing business development for RGA. And we were pitching a big project for a global financial services company that was building a new headquarters in the middle of Times Square. And they were going to they were planning a large interactive exhibit in the lobby. And we were one of the finalists to do this exhibit. In fact, we were the finalist. It was just a matter of negotiating this contract. So it was going to be a big, important project for RGA, and it was going to be a big, important project for me personally and professionally. Now, the guy on the other side of the negotiating table was really different from me. He was a project manager at one of the largest construction companies in the world, a firm called Skanska. And for anyone who's been involved in these large business construction projects, you'll probably know the name. So he was much older than me. He was way more experienced than me. And he was probably more accustomed to negotiating with Teamsters than he was with young agency business development executives. So I was intimidated for sure. And I also found that while I was unnerved by him, I was equally unnerved by this legal language that was put in front of me that I had to unravel. But luckily, he turned out to be a really unlikely mentor. One of the things that I learned from him and that really struck me was the way that he didn't hesitate to break down every paragraph of dense legal language into understandable human language. And that taught me some really important lessons. First of all, it taught me that everything is negotiable. We negotiated every single point in that contract. And what I learned is that just because it's written in important sounding language, it doesn't mean that it should be there. Everything is negotiable. The second thing I learned is that thanks to watching how he broke down all those deep, dense legal terms into ideas that were easy to grasp, what I realized is that those dense legal terms really were just fancy ways of describing business issues that I innately understood. And third, what I learned is that once I understood that, once I was really clear about what those business issues were and which ones were important to my agency, well, it was much easier for me to ask for what I want, to understand where I could make concessions, and then to walk away if we didn't get those concessions. Now, this unlikely mentor, he also made me more valuable as a business development person because I learned how to close a deal while also negotiating with the best interests of my employer in mind. And in my experience, sometimes the idea of negotiating with the best interest of our employer in mind makes us queasy. It makes us feel like we're undermining this new and fragile relationships. So I understand that feeling, but I also think that being a good sport today is going to lead to regrets in the future. And this webinar today is really about what some of those missteps are and how to avoid that future regret.
Well, and I think just to pick up on that for a moment, Jody, I think to your point about deciding which business issues are truly important to you, it is frequently the case when we're assisting from a legal perspective, an agency negotiate a contract where, there's the legal answer, then there are the business goals. And we typically find that somewhere in between is going to be the end product of a negotiation of a new client relationship as reflected in the contract documents. So not every single provision in an agreement that isn't written in a way that perhaps is most flattering or most attractive to the agency is going to be worthwhile enough to you as agencies to debate or bat back and forth between your legal teams and the business teams of the agencies. And so the job that we have is to work with you as business people to help you decide what's most important to you and to make sure that that's reflected in the agreement before you get started along the path of doing the work. So what we would first want to talk about, as we indicated earlier, are some of the common mistakes we see during the course of a pitch or a new business process. Oops. There we go.
There we go. Forward.
Sorry about that, guys. First of all, you and the client have not executed a non-disclosure agreement at the beginning of a pitch or an account review. Secondly, the work that you do in order to get the client ultimately ends up in you giving away too much of yourselves during the new business process. And in many cases, it's way more of yourselves than you really do need to give away in order to present yourself as viable and talented to the candidate. Number three relates to how you define scope and compensation in your agreement, and what you do when projects bleed out of scope, and how to address that during the relationship. We'll also start with, and it sounds extremely basic, but it's quite simple, and we've included it because you'd be surprised how frequently this occurs, starting without a signed contract. It wouldn't surprise me at all if there were agency leaders on the line who had eager clients and time-sensitive projects, and you went ahead and began work without having the ink dry on the contract. Next, it's dealing with this whole issue of the ability or inability to show the work that you do for a client further on down the line in new business development situations. And we'll tell you what we mean by that in more detail in a couple of minutes. And then next and finally, it's just having a lack of consistent process or a lack of tools to help your agencies more quickly and efficiently get through the contract process whenever you are in front of a new prospect. Frequently, this creates a friction and a loss of time and momentum that can be addressed simply by having a few tools and processes in place. So let's talk about how to avoid some of these common mistakes. First of all, no non-disclosure agreement between your agency and your client when you're beginning a pitch or an account review with a prospective new client.
Yeah, so let me paint a scenario which may sound familiar to you. You just got a call from the new business prospect of your dreams, and they call to tell you that their account is going up for review and they want you in the pitch, but they're moving fast. And before they can send you a brief, which they got to do right away, you have to sign their NDA. When you get the NDA, you realize it's complicated and it's filled with irrelevant clauses to the business of advertising. What do? Well, for some, the temptation is just to plow ahead, not to question the irrelevant clauses, or even worse, you decide that it's going to be way too time-consuming to decipher all that language and those clauses. And you don't want to keep the client waiting. You're already going into client-pleasing mode. Or maybe you just simply ignore some burdensome expectations around things like ownership of ideas or a necessary levels of insurance. That's something, in my experience, I've seen a lot, especially when I was working with bigger clients, like large retailers, large manufacturers. I mean, they work with all sorts of vendors, and to make their lives easier, they stick in all sorts of clauses in their NDA about because they're dealing with construction companies, they're dealing with distributors, they're dealing with a lot of companies that will have much higher liability issues and need much higher insurance levels, not advertising, and it shouldn't be in the NDA. So I guess the bottom line for me is that non-disclosure agreements are important. They don't have to be complicated or long, in my experience, and they should always be mutual. And I know Sharon has a few other words to say about NDAs.
I do, and I have a different perspective, or I should say an additional perspective on the reasons why agencies tend to blow past this step. And in addition to what Jody mentioned about the fast-moving nature of potential new business opportunities, a frequent reason for pushback, or a frequent reason for not moving forward with pushing for a non-disclosure agreement that I hear from our agency clients is that you all don't want to appear hard to do business with or difficult to your prospective new clients. And you're concerned that if you don't start the conversation with them without having a non-disclosure agreement in place, that it will set the relationship off on a potentially bad foot, that it might make you look difficult to do business with, there are the practical reasons as well that Jody mentioned about it slowing the whole process down. I guess I would encourage you from a legal point of view to try to get past that a little bit, and here is why. As Jody mentioned, the brands that you are pitching to or proposing to or in the mix with are not going to be at all hesitant about asking you to sign their version of a non-disclosure agreement. For them, in many cases, particularly if it's a large client, it's just a matter of rote. It is a part of the process, and it's sort of a checkbox that they have to click off before they can move forward with you. But for you, you are mobilizing your teams to put together ideation, perhaps strategy, ideas, things that will show the best of yourselves to a prospective new client. And without a non-disclosure agreement, leaving yourself vulnerable to perhaps not getting the business, but still having shared some of your best thought, leadership, and ideas with them. And so for those reasons, I'd like to encourage you to really think hard about the basis for sort of sliding past this whole process of avoiding the non-disclosure agreement. And as I've just said, I really hope that you'll be less hesitant in the future, if nothing else you take away from this, about thinking about not only the confidentiality aspects of the agreement, but the mutuality of it. Certainly, you want to emphasize to a prospective client your full intention to keep their information confidential, as well as protecting the confidentiality and ownership of anything that you share and disclose during the conversations. What's the solution here? If speed is your problem, if needing to start quickly and getting past this formality quickly is part of the issue, and you don't want to leave yourself vulnerable simply to signing whatever the client proposes to you, have your own version of a mutual non-disclosure agreement in your toolkit as an agency. Make it part of your standard process. You heard me mention in the beginning of the presentation the importance of having a process and having the tools, and this should be a necessary tool in your toolkit so that there's not the skipping of a beat when you're in a position of having to start a conversation. You will have the tools, and you will already have an agreement that's written mutually and that has addressed all the concerns that you have as an agency for protecting yourself. So the next mistake we want to talk about is this somewhat sensitive issue sometimes with agencies of giving away work for free during a pitch, a proposal, or other new business situations.
Yeah. So what I found is agencies hate the idea of doing work for free during a pitch. What I've also found is that usually they can't help themselves and they do it anyway because they feel like the client is demanding it, or they feel like their competitors are going to do it anyway, and so they need to. So they feel a lot of pressure to do it. So unfortunately, that's not a problem that's going to be solved by any of us during this webinar. So we'll leave that for another time. But in the meantime, the way I suggest to hedge against that is to be more discriminating and even more mercenary in the way that you decide to do spec work. And this is where I think a very tightly defined set of selection criteria that you have in place at the beginning of this pitch process can be crucial. So I tend to approach decisions about whether or not to pitch in a similar way to deciding how I'm going to invest my money. Like investing, pitching is risky. You may invest a lot and you may not, and your return may be very low, or you may even lose money. I'm not just talking about losing the pitch. I'm talking about losing the time and money that you've invested in doing that work. So each pitch has its own risk-reward ratio, and that ratio is going to be based on your own set of criteria. And a lot of that is going to depend on how you want to grow, the categories you want to move into, the types of clients that you need to work with, the size of clients that you want to work with. But really, you're the only ones that can determine that. For instance, a potential reward like the prestige of working with a new client in a category that's desirable to you, or sometimes just the revenue of the client that's going to spend a lot of money with you, that could offset the risk of investing in doing spec work. But as I said, it's really a decision that has to be made by you. Now, sometimes you're able to negotiate a modest fee upfront for pitched ideas, and I think that's something that's becoming more and more common. On one hand, that's good. I think clients are starting to realize that it's that they need to compensate the agencies for the work that they do. One of the downsides of this compensation is that depending on the NDA or the initial contract that you've negotiated with the client may own those ideas for a discounted rate, because typically the amount of money they're paying you is not really going to cover the work that you do. So I guess the bottom line is, really the bottom line is to avoid doing spec work, avoid it from the beginning, and do that by positioning your agency as a source of unique insights and experience that the competitors aren't going to give, and find other ways of communicating that. If you feel the pressure to do spec work, be very careful about how you decide. Do that risk-reward ratio to figure out how you're going to, whether it's going to be worth it for you.
Right. Well, and I'm an intellectual property lawyer by training, and that is how I came to start working with folks in the marketing and then in the agency world. And so I have a specific point of view about this. You can take a very hard line about this and really sew it up quite tightly. And for some agencies, that's the right answer. For other agencies, Jody and I could sit here and tell you all day long why either deciding to do spec work or deciding to put a lot of your strategy into written proposal documents that you share with the clients are not good ideas, and you'll choose to do it anyway. I'm fine with that as long as it's the agency making a well-thought business decision about table stakes in order to approach this client for the prospect of maybe doing business with them. If you've made a business decision that either doing spec work or not doing spec work, but giving away some of your ideation, your concepts to the client during the dating phase of the relationship makes sense for you, then my job as a lawyer representing agencies will be to help you protect as much of that as is in your interests, given what your business goals are. So there really is no right or wrong answer here, because it's a business decision for every agency to make. My whole train of thought on this is that make sure it is a conscious and thoughtful decision, and that you realize that you've decided to do it and that your documents reflect it. I think sometimes what agencies do, the misstep that I see them make, is they haven't really thought it through, and then they find themselves in the position of perhaps not winning the business and having given away more than they suggested. So I don't want to see an agency in that position, and my goal is to typically help them avoid that. If you have decided that you want to protect some of what you're sharing with a potential new client, and you've decided to not go the non-disclosure agreement route, because I know perfectly well from having worked with agencies for a while that some of you will sign a non-disclosure agreement and some of you will move ahead without one. If that's been your decision, or if you simply haven't had time to address that part of the process, there are some other things you can do in the actual pitch documents and assets that are exposed during this part of the conversation to protect yourself and put yourself in a better position. First of all, it's as simple as making sure you put copyright legends and ownership notices on the assets that you show them, which means, second of all, to the extent that you can put your ideas in visual form as much as possible, or written form, the copyright law can be your friend, because it only protects the expression of an idea, not the idea itself. So think about putting as much of your ideation in writing or in visual format as possible. And then in your actual proposals or in your responses, for example, to RFPs, put carefully worded ownership statements about the content of those documents in there, so that you're making it clear to the client or prospective client that what's in there belongs to you, unless your agency and the client have agreed otherwise. As Jody mentioned earlier, and Jody, I don't know if you want to talk about whether you're seeing this done more frequently as of recent, but the other solution is, and again, to Jody's point, you're not going to be made whole, but negotiate a fee up front for this stuff, and you may still be out money at the end of the day in terms of your pitch costs, your hard costs and sunk costs in pursuing the business, but at least you won't have this issue hanging over your head over who can use what, and that can be used for your peace of mind.
Yeah, it's a trend that was pointed out to me that I don't have as direct experience with, but a trend that someone else pointed out to me is that what they're seeing is the clients now. So I guess, a few years ago, smart agencies would say, fine, we'll do some spec work. Or no, we'll say, instead of doing spec work, pay us to do a short discovery session. You get to keep and own everything that we find out, the insights we discover for you, but this is a lower risk way to figure out if we're going to work well together. And when you were the only agency that was suggesting that sometimes could be a real good competitive advantage, and sometimes you could convince the client to do that. So what I was told is that, in fact, now what's happening is the clients are getting smarter. I guess that would be the way to say it, is that now clients, what they're doing is they're saying, okay, fine, I'll do a discovery process with all of the agencies we're considering, or the short list of 4 or 5 or 3. So you may be getting compensated, but you're still in this competitive pitch situation. I don't know if I've got the right solution for it, but it's I guess at this point now, be aware that that's something that's happening, and make sure that you know that it's happening. Ask the client if they're going to be, if they decide to go that route, if they are doing that with other agencies or just yours.
Right. Well, and as we see agencies evolving, some agencies evolving more into consultancy models, it's just something to think about, because if that is your business model, or if that's your desired business model, you want to make sure that the pitch fee, if you will, that you've negotiated for that discovery document is reflective of what you think the value of the discovery is to you. Because if you're an agency that makes money on execution and media as well, then perhaps the value of the actual ideation is not as high for you as it is for an agency that has a more consultative model.
That's a great point, Sharon.
So let's talk about you're past the new business stage of the relationship and the conversations, and you and the client have decided you're going to do business together. And now it's time to talk about what the actual agreement, the service agreement between the agency and the client will look at. One mistake we want to talk about is how you define work scope and compensation well in the document to avoid problems down the road.
Yeah, so, I know, as Sharon was saying, we're talking about the point where we are negotiating contracts to close a piece of new business, or right after we've done that. But I think this mistake can be tracked back to the strengths of an agency's positioning. And of course, I'm a little bit biased because I'm a sales and marketing expert, but hear me out here in this. So I think that some agencies can find it very difficult to describe what they do in concrete terms. And there's a really good reason for that. And that's because what you do is largely intangible. So when you think about it, your value to your clients is really derived from your ideas, how you got to those ideas, and then what you're going to do with those ideas. And you probably do your best to bottle that haphazard idea generation in some kind of work process or methodology. And that's going to give some shape to that activity, but it's still pretty abstract. The problem is that the more abstract something is, the harder it is to sell. So putting it this way, you will understand what you want to pay for something tangible, like a doorknob or a jar of peanut butter, or even a service like getting your hair cut. Those are things it's relatively easy for the value of those things to be articulated to you quickly, and sometimes simply by picking that object up off the store shelf. On the other hand, the more abstract and unfamiliar a product or service is, the harder it is to convincingly convey its value. Attempts are made often, and this is where you see things like jargony phrases or generalizations or overblown descriptions. The example that comes to mind is the way agencies will tend to describe a rigorous process without really defining what makes it rigorous. Sometimes because the agencies haven't actually done that work to figure out what makes it rigorous versus another agency's rigorous process. But terms like that are abstract. It's very hard for the client to really understand where the value is coming from. And that's a lot of what I do with my clients. I work with them to help them translate those intangible services into tangible ideas and sales messages. Now, this is very useful when it comes time to tell the client what you are going to do in exchange for their money. The more tangible, the more you can describe those services and the value in tangible terms, the more it is going to be easier to define your scope of work and how you should be compensated for that scope of work.
Well, and I think from a legal perspective, the agreement that you end up signing with the client is the true reflection of the meeting of the minds about what it is that's going to be done and how much is going to be paid for it. And so the more clear you can be in your statement of work, in your proposal, whatever portion of your service agreement actually discusses what you will do and deliver, the easier it's going to be to remedy any misunderstandings later on down the line, because you have a reference point to go back to that was mutually negotiated by the parties. So it's really worth doing some upfront work, even if it delays the contracting process a few days here or there, to make sure you're very clear in the phases of the project, the descriptions of the work, and how it's all going to tie to the money. I think that one area we also see clients and agencies get into some trouble with, and Jody, I don't know if you have any examples of this from your work with agencies, but frequently we know that agencies are always pressed for margins. Your margins are shrinking and shrinking because there are increasing pressures from the clients on things like rates and expenses, and so the worst thing that can happen with a really big piece of business with a client is that it end up being terribly unprofitable for you as an agency leader, because the agreement wasn't specific upfront about how many rounds of revisions your team would be available to do, how you would handle changes either in direction or scope of the project, and what that would mean for the money. And I always feel badly for agencies who have projects that get taken in a new direction by the client, and before you know it, you see the agency in a position of working for very razor thin margins, and it makes it hard to stay motivated to keep the client's interests advancing, because it's an unprofitable piece of work. And that's something that can also be thought out ahead of time, not just in the agreement itself, but in a carefully laid out process for how you will handle dealing with and documenting any changes or scope revisions.
Yeah, I agree. Although I also agree with Sharon that it's one of these things that it's sort of like, it's a little bit like herding cats, because every time you've been able to nail down, you've been able to put language around something you will or you won't do, something else escapes. I sort of, like I compared something else to investing, pitching to investing. It's almost like putting together the most fair last will and testament as possible. There's always someone who's going to feel screwed, because you as that person who is writing could not possibly anticipate everything that's going to happen in the future. So that's where it's a little tricky. And I also think that's where it maybe helps, rather than solving that problem by defining how you're going to get approvals and how many rounds, is to take a step back and think, can we instead negotiate this scope from by looking at the outcomes and agreeing on the outcomes. And I think sometimes we can bring the client back to those outcomes, that you start to see the bigger picture. Also, if you're going to be negotiating, or if you're going to be building a scope based on outcomes, and you can tie potential revenue to those outcomes, and that revenue is significant, you can often negotiate a higher fee as a percentage of that revenue that they're going to generate, and that also then builds in an automatic cushion for you, so that rounds of revisions have they're less of an issue. It's more about creating work that's going to lead to the outcome.
Right, and I would just, before we leave this point, throw into this category as well. I was just speaking with a group of agency owners last week, and a couple of things that came up in this neighborhood, if you will, are things like dormancy fees for projects that go dormant because the client simply doesn't take action to move the work forward. think about if that's something that's been in your experience as an agency, whether that needs to be addressed in the agreement. A project restart fee for projects that have gone, because there's a cost to your agency of having to remobilize your team, get them off of the next piece of business they're working on when one client's gone quiet. There's a cost to that loss of momentum, and it needs to be reflected in some cases in the agency's agreement. So I'd throw those two as well in this same category of specifying the number of rounds of revisions you'll do or the number of changes that you'll do without additional charges.
That's a great point.
Yeah, and then I don't want to forget about this as well. Rush work policies. This is something that I really counsel agencies to think about addressing in their agreement as well, especially for production or design heavy agencies where there can be a lot of iterations to get something to be just right in the mind's eye of the client. And there can also be unrealistic demands made by clients. Everybody on this call knows that. They've gotten those calls at the 11th hour about something that needs to be changed or a direction or course that has gone differently. If you have ever been burned in this way, then I think you'll understand the importance of addressing additional fees for rush work requests in your, not only your proposals and your statements of work, but your master services agreement as well.
Yeah.
The issue of premiums, we really included it here in the presentation very quickly because many of you are becoming or are already category specialists. And I know, Jody, you have a point of view on this specifically, but the whole issue of charging premiums in your agreement comes up in most cases. We see it come up here in the firm where a brand is demanding exclusivity from your agency in a category or in an industry. And my point of view on this is that, and this is really more of a business judgment than a legal judgment, but if you're going to agree to those sorts of narrow definitions of your ability to work for other companies in the category or other products in the category, you should be negotiating a premium for that exclusivity. And Jody, I know that you and I have chatted about this in the past as well.
Yeah, and I know this is also really tricky because you're like, but it's Walmart or it's Disney or it's some enormous client. I can't say no to them. But I also think that, as Sharon said earlier, it comes down to business issues. And it's probably worthwhile figuring out if how this is going to impact future revenue, and then presenting it to your client. And if they don't care, if they find that immaterial, then you have to look at that business issue and say, well, does it matter to us that we'll never be able to pursue another entertainment client for as long as we're working with Disney? Maybe it doesn't. But I think if you look for that in that longer term, you may find that, despite the fact that this is an enormous, great big win, if they're not going to let you work with clients, then it could be really damaging in the long term. And it's not such a great client for you.
Right. Well, I know that you've mentioned in the past, Jody, using this. This is also a leverage tool for agencies as well, because if you want to be able to, display your chops as an agency in a particular vertical or category.
Yeah. And I think we're getting to that in mistake number 5. I'll definitely be talking more about that there.
Okay, cool. Perfect. All right, carrying on. All right, so starting without a signed contract, and I can't see you all, but I know some of you are probably rolling your eyes because of the obviousness of including this in the deck, and I get it. I would also say in the same breath that there's probably not a single one of our agency clients that hasn't contacted me at some point or another to say, we've already started work. We sort of have an understanding about what's going to be done and what the goals are. We just need to finalize, the paperwork, if you will. And so they've, in many cases, and it's not hard to understand why. Again, it's the same set of rationales that keep agencies from wanting to look difficult, demanding non-disclosure agreements or have conversations about other sensitive legal issues. You do it for a couple reasons. You do it because you're excited about working with the brand. You don't want to lose momentum. You don't want to look difficult as a vendor or a strategic partner. And Jody, I know you have a point of view on this as well too.
Yeah, I mean, and I also just have to say, full disclosure, guilty as charged. I've done this. I did this in my past agency career. Sometimes, well, probably most of the time, it actually wasn't my decision. It was the president or CEO of the agency who said, we'll be fine. Let's not piss off the client. And I will also admit that sometimes it is fine. See, that's the problem, is that there are those handful of times where you may work with a client for several years without a contract, and it's fine, but it's really risky. So I'm going to start this also with another issue that may seem divorced from this idea of contract negotiations, but it's also something that I think does affect it and that agencies struggle with. And that is this idea of committing to a niche. And I know that's also the ins and outs and the debate around that. That's another whole topic for a separate webinar. But if an agency can't differentiate itself through competitive positioning, then it has to start to rely on subjective factors that are harder to control. I think that's just a fact. You can argue about whether you want to or why it makes sense for you not to explore a niche. The more general you are, the harder it's going to be to compete. And so those subjective factors, those are things like whether the prospect's going to like the spec work that you've also decided to do. A lot of times your strategy can be great, but someone doesn't like the color purple and your campaign is all around the color purple, right? So it's very subjective. You can't control that. Another thing that's very subjective, difficult to control, is good chemistry between your team and the client's team. And I'll admit, chemistry is important. Showing that you are easy to do business with can win you new business, can win you pitches, especially when all other aspects of the playing field are level. But this also makes saying no to starting work without a signed contract very hard, because it means that even if it means that you're going to, eventually it's going to turn out to be disastrous. So here's what I say. You will never be in a stronger position with that client than at the moment when the prospect has agreed to hire you and before you sign the contract. Now, the moment that you do the work for the prospect without a signed contract, you go from your position of greatest strength to a position of great weakness, and that fall is quick and absolute. So if you find yourself tempted to please the client and start work without a contract, I want you to get out of your own head for just a minute. And this is where you have to start putting yourself in the head of the client and rationally think about their situation. Like you, they've just made an investment in time, in resources, even an emotional investment, because it's emotional for them to choose an agency as well. So I ask you, what is the likelihood, if they've traveled down that road with you so far, what's the likelihood that they're going to walk away from that investment because you won't start without a contract? I personally think that the likelihood is, I don't think it is very likely. Alternately though, look at this. What's the likelihood that if it does end up disastrously and you do start without a signed contract, what's the likelihood you're going to be able to recoup costs, not to mention protect your intellectual property or prevent poaching of valuable employees if you don't have a signed contract? You got to decide whether it's worth the risk.
Right. Well, and I think too, this relates to one of the other frequently made mistakes we'll talk about shortly, which is part of the problem is a practical problem of timing. It's again, as I've said earlier, not wanting to lose the momentum, and you can avoid some of that by being quick to get the process executed, by having tools in place and actually having thought through your client onboarding process, not just from a client relations point of view, but from a legal point of view, so that you can get this done quickly. It doesn't need to be a big drag on everybody's enthusiasm, and you can get the agency in a position of protection as quickly as possible. And then another reason why it's so critical to be thinking through this early when you do have leverage, as Jody points out, is because you need to be thinking, I think, proactively. This is what we emphasize at the firm, is being proactive rather than reactive whenever it's possible. Think about what the worst case scenarios are if the relationship ends up unsuccessfully or needing to sever for some reason. you need a roadmap for how that's going to unravel. That's your contract. Your contract is as much a roadmap about how you will do business together as it is how you will, part ways if and when that occurs. And so you need that roadmap. Otherwise, you're sort of making it up as you go, and you're increasing the likelihood of messiness. And I think we've addressed this pretty carefully. You need to know upfront what your legal options are later, and that includes things like recovering your collection costs, recovering your attorney's fees, recovering, what your options are in terms of restrictive covenants if the client behaves badly. Referring back to your contract as your roadmap here makes skipping this step pretty risky. And I agree with Jody that in many cases it ends up okay. I can also tell you that it only takes one instance of it not working out okay to make true believers out of your agency's leadership on this point.
Okay, this one is a really tough one. So I think it's so ironic to me that when clients deny portfolio rights, I think it's ironic because those same clients would never hire an agency without having seen examples of work done for other similar clients. Right. So they're denying you the ability to do exactly what they asked you to do for them in order to feel good about hiring you. Simply not fair. And I think you have to let them know, you have to make them aware that they are limiting you from being a successful business. So again, this is also where starting work without a signed contract makes you vulnerable, because this is, you have to take advantage of that position of strength to secure the ability to publicly showcase the work that you're going to do for that client. Now, again, to bring up a client like Disney, because I know in my past, Disney has been notorious as one of those clients that doesn't let you put their logo on your client slide. And so it's hard when a big client like that says no to showing their work. So this is where you got to go back to your selection criteria, your risk reward analysis, and you have to determine if the potential rewards offset the risks or the losses. So if Disney is just going to be an enormous cash cow, then maybe it doesn't matter if it doesn't matter if you can show the work or if you can talk about them being a client. But I think usually an agency's future health and success depends on being able to show the work that you're doing today. So here's the way I present how you can present your case and how I do that before. I usually say that, when clients hire you, they want to make sure that your business is a healthy one. And that's why sometimes you see in RFPs or RFIs questions around what your billings are, how many clients you have, how many clients you've won or lost over the past few years, where all of your risk is. Do you have an overly large client versus many small ones? So in other words, and how do you stay healthy? Well, one way is to grow your existing clients, of course, but the other way is to attract new clients. And how do you do that? You do that by demonstrating your experience. So in other words, a client that is preventing you from showing your work to other prospects is essentially weakening the value of their investment, because they're not allowing you to continue to be a healthy and dynamic agency. The client really is cutting off its nose to spite its face. So what you potentially can do, if you are able to reflect that problem back to them in that way, it becomes a business issue for them as opposed to just a complaint of yours. So the other thing also, if they're still hesitant to let this go, I often ask why. Why is this important to them? And by the way, I think that's in general an important guideline for almost anything that we're talking about today. If a client is stubborn about letting go, ask them why, so you can really get to the bottom of the business issue. So maybe it's because they don't want to share you with other competitors. Maybe they're worried that your case study is going to reveal a kernel of proprietary information. Once you know what that real concern is, it's much easier to then address that and present a compromise that works for both.
I agree with that. I think I have a couple observations on what you just said. I agree with that, and I also think this ties back into the whole issue of identifying compensation and exclusivity. the whole issue of exclusivity and the thought process behind charging a premium for it relates to this issue of not being able to show your work in a promotional portfolio and a capabilities piece later on down the line. And so you need to think about them in parallel with each other. And then, I also, Jody makes the point, and I'm going to let Jody discuss this point because I really love her point of view on it. I want to just give you a couple practical takeaways about where to look for this issue, particularly in the client's version of a master service agreement. It's going to show itself in either the confidentiality language that appears in the client's version of a master services agreement, or it's going to show up in the intellectual property ownership section of a client's master service agreement. So you want to be looking in those sections of their agreement for language, not only that states that they remember that portfolio rights and the ability to display works or logos in your portfolio, they're an intellectual property right. So to the extent that the intellectual property language in the agreement does not have a carve out for this stuff, for your ability to display some of these assets promotionally, that's going to be a problem for you in terms of being able to show the work to future prospects. To the extent that the definition of confidential information in the client's version of the master services agreement includes everything under the sun that you've created for them, it may also bind you similarly from the ability to show this stuff later on down the line for your business development purposes. So be looking for it masked in those two sections of the agreement.
And you don't want to wait. I think most contracts do have that type of clause baked in, but or don't say okay to appease the client and then figure that you're going to butter them up later on and try to get that changed. I mean, it's not impossible. You might be able to, but go back to this idea that once you've got that contract signed, you have lost so much of your strength. You have very little leverage to go back and say, oh, come on, can't we show the work? So take advantage of it while you can. And, this also goes for references. And in some ways, this also has to do with saving of time. I feel like I've witnessed and been part of mad scrambles. It's always, for some reason, the last thing you do when you're getting ready to go into a final presentation or prepare your final documents for the pitch is the scramble to get references. So set that expectation early on at the same time you're negotiating for portfolio rights, that if the client, assuming the client is happy with the work that you've done and you have met those measurement criteria that you've set, make them understand, give them the expectation that you're going to be coming back and asking them for a reference for other future clients.
Yeah, and then I guess my final remark on this point is to Jody's earlier point about really probing a little bit further to see what the client's business goal really is here on this topic. Many times you're going to find they don't really have a point of view that is specific about it. If their process is heavily driven by procurement or by their legal team, or if it's a smaller client that is in an enterprise, if it's just driven by the fact that they have a standard professional services agreement they like to use, this is just something that at some point someone decided was good to include as a matter of process in their document. They may not really have thought it through as carefully, and therefore it may not be an important business issue to them at all. So I think it's important to take Jody's suggestion and really probe a little bit further. Yeah. And as Jody indicated, not handling this up front means you're left asking later for either a testimonial or permission to use a sample of an asset. And you're probably not going to be able to find the right person or get the okay in a short enough time frame to do you any good in your next new business presentation. And then we've discussed how to remember to look for this in the IP sections and the confidentiality sections. This is a right that needs to be carved out in your agreement. And if you don't carve it out, then you won't have a lot of leverage to try to enforce it later. All right, so we want to talk a little bit about process And I know that this is not why any of you got into the agency business. It wasn't to be thinking through contracts and glide paths for clients from a legal perspective, and all the kinds of things that you are in creative industries to try to avoid on a day-to-day basis. It also doesn't sound like a fun thing to invest your operational dollars on, but I can tell you from a lot of experience that taking a little bit of time up front to put process and tools in place will make everything else we've talked about up to this point a lot more logical and a lot less expensive and a lot less time consuming. So the first suggestion that I have in this regard is take a look at what you're doing now. Take a look at a client negotiation experience from a documentation perspective or from an onboarding perspective that has gone really well. And I'm not just talking about the chemistry, although that's a huge part of it, but I'm thinking about the documentation portion of it. And it's probably something that's the opposite of what I'm about to describe. You bring on let me describe a typical agency scenario where it isn't so frictionless and flawless. You've got a team of account executives. First, they each handle the onboarding and documentation for the business that they are in charge of bringing into the firm. They are in charge of getting the contract prepared. They're in charge of getting the client sign off. They probably confer with you as an agency leader about negotiations and things like that and portions of the business deal. The actual legal terms and conditions are probably something they Frankensteined together based on a couple of contracts they found in your agency's database or maybe from the database of the last agency they worked at. These are all real scenarios. I'm not making any of these up. These all happen. And at the end of the day, you've got a roster of clients whose contracts look nothing like one another's. That's probably an example that can be cleaned up a great deal just by having some thoughtful processes in place. You're never going to have complete consistency from deal to deal because sometimes you're going to be able to use your own contract. Sometimes you're going to have to use the contract that the client has proposed to you. But consistency is so important and such a time saver and a dollar saver. So what are some of the things that you can do to get yourselves there? First of all, centralize the process. I'm not a big believer in it being a great idea for each account team to be handling the contracting process for its handful of agency clients sort of independently or in a silo. I think the contracting process for new agency clients should be centralized. I think either one individual, if you are a small agency, or one group of individuals or department or team of individuals, if you're a little bit larger, should be handling this as a business affairs matter, should be vetting agreements, should be reviewing client versions of the documents versus your standard paper, and should be coordinating the negotiations back and forth. It's a lot easier to spot inconsistencies and issues, and it's harder to make mistakes when you've got consistency built into the process. I would add to that having your own set of legal tools makes this process a lot less painful for the agency because you have a benchmark, you have a checklist, you have a punch list, if you will, of things to be thinking about when you're reviewing a document you've never seen before, if you have your own version of the document internally that you use as your bedrock. So just from a perspective of benchmarking, makes it so much faster to review the paperwork involved in a new client relationship than it would be if you're starting from scratch every single time. So consistency of process, consistency and consolidation of eyeballs on these documents, and then having your own set of tools are, in my experience, great ways to help yourselves in this process. All right, so we've gone pretty quickly. So we would like to review some of the fixes that we've talked about to these common agency mistakes in new business. And I think, Jody, I'm going to kick it over to you to talk us through the first three.
Yeah, sure. And I know that we're probably going over a little bit, so I appreciate if for people who could stay around. And Sharon, are we offering for people who can't stay around an opportunity to ask questions in the chat box?
Yes, we are.
Okay.
And we'll get
So
to
anyone
that.
who has that. And also for follow-up, I think Sharon and I are more than happy to provide our contact information, so you can reach us privately as well. So here's some of the common mistakes and how we fix them. Have it for the times when you need to turn around an NDA fast, especially if the client says you got to sign this quickly before I send you the brief. Have a standard one ready so you can say, yes, in fact, here's ours that we use. Number two, make sure that giving away spec work is your choice and you're doing it on your terms. That's the ideal. Number three, define scope and compensation clearly. Try to make the wording, the language around what you do and why it's valuable as tangible as possible. And maybe even take a step back and figure out how to get away from the language around rounds of revisions and more about outcomes versus outputs. And then number four, Sharon, if you're able to scroll up.
I'm trying.
Oh, sorry.
The slide froze on me. There we go.
Okay.
All right. All right. I'll take this one. Never start without a signed contract. I know you will not all heed this, but please minimize the chances for issue by having your policy be to not start work without a signed contract. Remember that portfolio display rights, whether it's your client's identity or samples of the work you've done for them, are an IP right, and you need to negotiate this up front or you'll have very little, if any, leverage to do it later. And then as we've just discussed, have a defined process and set of tools for documenting your new business so that you can get started doing what you're all in business to do, which is create great business results for your clients and do creative work. So thank you for hanging in. We started a minute or two late and we're ending a minute or two after the hour. Jody's information is on the slide, as is my information. If you'd like to reach out for either a copy of the deck or our firm's checklist on reviewing agency client contracts, one side of which is a list of things to put in your agreement, the other side of which is a list of things to look for in the client's version of the agreement, please reach out to me. I'm happy to have that sent over to you. And if you'd like to reach Jody, Jody's is there as well.
Yeah, and in fact, I also offer, if you go to my website at thesuttercompany.com, you can also download a free pitch checklist, pitch or pass, and that also has some questions that you can start to ask yourself when you're faced with these pitches and you're uncertain whether you should pursue or not. It'll help you decide where the risk-reward ratio lies.
We want to thank you for taking the time to talk with us today, or to listen to us talk with each other about new business. And I'm going to leave this slide up for a minute, so if you want to copy down contact information, you can. And I'm going to leave the chat window open for a minute or two as well. I'm not seeing any questions. Yeah.
We must have done such a great job, Sharon.
I think we must have. Or hungry for lunch if they're on the East Coast here in the United States.
That's right.
All right, everybody. Thank you so much for joining us today, and I'll look forward to meeting some of you soon at a TAAN function.
Thanks, everyone.
Bye-bye.
Bye.
Oh, we got it. Will we make the recording available for those who registered? Yes, I have to check with our administrator about whether or not we can do that, but if we can do so, then we will make it available to everybody. Thanks, Peter. Have a great day, everybody. Thank you. Bye-bye.